of the UN-approved regional in violation of the UN-approved likewise in 2022 Ukraine escalated its attacks against Donbas Ukraine escalated its attacks against Donbas republics. Both in violation of the Minsk agreement of the seceding states. The difference between these cases lies in the complete lack. The difference between these cases lies in the complete lack of the legal basis for NATO's armed attack, NATO's armed intervention in Kosovo, to which I will come in a moment. As you all know, the vast majority of the intervening states have recognized the independence of Kosovo. Ukraine did not heed any warnings and only escalated its strikes. On 24th February 2022, Russia together with DPR and LPR were forced to invoke Article 51 of the UN Charter. Distinguished judges of the court. This shows that Russia acted under Article 51 of the UN Charter. But this courtroom of the UN Charter has only recently been full of people representing states who did not act under Article 51. Who did not force against sovereign state, under a pretext of alleged genocide that has never been confirmed. Another crucial point for the special military operation that Ukraine seeks to pass in silence is Ukraine's disdain to the main Minsk agreements. Despite Kyiv's brutal assault on Donbas, has at that moment neither recognized DPR and LPR, neither recognized military operation for their defense, nor conducted military operation for their defense. Russia has been hoping to implement Minsk agreements, has been hoping the 2015 peace accord between Kiev, Donetsk, and Lugansk, endorsed by the Security Council and supported by France, Security Council and supported by France, Germany, only required Ukraine to grant autonomy to Donbas, while preserving its territory to Donbas, but while preserving its territory. But instead acting by force of arms. Last week, Russia's agent explained how Ukraine and its Western sponsors revealed how Ukraine and its Western sponsors to fulfill the Minsk agreements. Never intended. Kiev has in effect rejected them by numerous and substantive violations. A list of them is available online, and in the judge's phone. Ukraine rejected the implementation of the peace plan. Ukraine rejected the implementation of the peace plan and never stopped striking. Madam President, members of the court, Ukraine also wished to strike out 8 years of war against Donbas. According to OSCHR report on Ukraine, during the conflict period from 2014 to 2022, from 2014 to 2022, OSCHR recorded a total of 3,107 conflict-related deaths, including 152 conflict-related deaths, including the number of injured civilians is estimated. The number of injured civilians is 7,000. The majority of civilian casualties took place in DPR. The majority of civilian casualties took place in the real number of casualties is much higher. The real number of casualties killed or injured fell within the sight of international monitors. According to the authorities of the People's Republics, until 2022, more than 6,000 civilians were killed, more than 6,000 and about 16,000 were killed people, including more than 16,000 children, including more than 400 people on their territory. Were injured. It was due to mass shellings of residential areas in Donbas in order to punish the people of Donbas who refused to recognize the neo-Nazi regime on the 14th of April 2014. Kiev began a full-scale military operation. The right-wing radicals burned down around 46 civilians who called for the establishment of a federal system in the building of trade unions in Odessa. In the building of trade unions in Odessa. A few months later in the city, President Poroshenko made his infamous speech in which he promised that the people of the Donbas would have neither pensions nor salaries, and their children would sit in basements instead of going to school. On 14 July 2014, the Ukrainian forces shelled Mirny and the Ukrainian forces shelled Mirny, and as a result, at least 17 people were killed. Lugansk City Council reported 93 civilians. Lugansk City Council reported 93 civilians injured between the 1st and 28th of July. Injured between the 1st and 28th damage to buildings, including schools. There had been extensive damage to buildings, including schools. A month later, Ukrainian Gramatski TV published the story called Lugansk. It showed Ukrainian MLRS firing towards Lugansk from the outskirts of its suburb Veselaya Gora. On the same day, 11 people were killed in Snizhny, Donetsk region, as Ukrainian forces conducted an airstrike against residential area. On 27 July 2014, during a massive shelling of civilian residential area in the city of Gorlovka by the Ukrainian army, 22 people were killed. In total, in Gorlovka, 52 persons, including 9 children, were killed, 170 injured between 27 July 10 August 2014. Several times the Russian Federation has shown in this room a photo of trolleybus that was shredded by Ukrainian projectiles that fell in Donetsk in early morning on 22 January 2015. The OSCE SMM monitors confirmed that the deadly projectile was fired from Ukrainian forces' positions. The Ukrainian armed forces regularly attacked critical facilities, leaving the civilian population of Donbas without access to water, electricity and sanitation. For example, the Donetsk filtering station, which supplied water to more than 300,000 people on both sides of contact line, had to suspend operations several times because of Ukrainian shelling. Ukraine also blocked attempts to fix the station, attacking station workers. For example, on 12 March 2018, near Yasinovate, the Ukrainian military perforated a bus station full of workers with machine guns, wounding 5 of them. On 3 May 2018, the OSCE SMM chief monitor Apakan made a special statement that hundreds of ceasefire violations have been recorded on a daily basis by the SMM in the wider area surrounding the Donetsk filtration station, endangering lives and jeopardizing operation of the facility. Now look at these smiling faces. On this photo taken in 2019, President Poroshenko stands with Irina Gerashenko, an MP from Poroshenko's party. It was she who, as Ukraine's representative in the humanitarian subgroup of Trilateral Contact Group, part of implementation mechanism of Minsk agreements, regularly impeded its meetings, refusing to sit in the same room with representatives of Donetsk and Lugansk. This photo was published on the Facebook page. Now these two are staying in front of a damaged house in Avdiivka, together with an embarrassed local teacher whose students were hiding in a basement, and smiled. Ukrainian attackers gave no mercy to children. On the next slide, you can see the Alley of Angels in Donetsk. The names of the children killed by Ukrainian strikes are engraved on the granite slab. 4 of them were not even a year old. 10-month-old Sofia Danilkina was killed on 21st January this year as a US-made HIMARS missile fired by the Ukrainian forces hit her family's house in Kremenaya, LPR. On 14 March 2022, Ukraine hit the center of Donetsk using a .UN missile with a cluster warhead, leaving 15 people dead. You see the consequences of this attack on the next slide. At least 5 children were killed on 8 April 2022 as Ukraine launched .UN missile towards the railway station in Kramatorsk. The aim of this horrific attack was cynically simple: to intimidate civilians so they would keep away from any public transport and stay in the town. Thus, Ukrainian forces could use them as human shields. Kyiv propagandists, as always, groundedly blamed Russia for this attack, but they forgot the main thing. Russia withdrew .UN missiles from service many years ago. 3 months later, on 5 July 2022, a 10-year-old girl was ripped in half in Donetsk by a NATO shell fired by Ukrainian forces. On the next day, President Zelensky said, and I quote, "Finally, it is felt that Western artillery, the weapons we receive from our partners, started working very powerfully." Its accuracy is exactly as needed. Many children were killed or wounded by Ukrainian mines. From the very beginning of SMO, the Ukrainian forces have been using MLRS cluster rockets to scatter Lepestok anti-personnel mines in the cities of Donbass. On the slide, you can see a 15-year-old boy wounded by such a mine. It is worth recalling that children's personal data were posted on the infamous Mirotvorets peacemaker website, which is a shooting list of the Maidan regime. Over 350 minors are listed on this site without any impediments from Ukrainian authorities. On the slide, you can see the profile of 15-year-old Faina Savinkova, a young writer from Lugansk, who was listed on the site when she was 13. The portal administrators refused to remove her personal data, even after special warning from UNICEF. In our preliminary objections, we have mentioned that the Russian Federation was the country that hosted the largest number of Ukrainian refugees in the world. To be more precise, since February 2022, the Russian Federation received about 4.8 million residents of Ukraine and the Donbas republics, of whom more than 700,000 were children. The overwhelming majority of minors arrived together with their parents and other relatives. About 2,000 orphans were moved for the security reasons from orphanages in Donetsk and Lugansk and accommodated in children's institutions in Russian regions, far from the front line. These people choose Russia to be their shelter. Ukraine now dares to say the evacuation of children from this constant shelling and bombing were abductions. In their view, children should have been kept in the line of fire of the Ukrainian cannons. Since 2014, the Ukrainian army had widely used residential areas and social significant facilities in Donetsk and Lugansk regions to cover its troops and heavy weapons. At the same time, the Ukrainian forces intentionally used weapon systems from residential areas, aiming to provoke return fire and then blame Russia and DPR and LPR militia for the consequences. Thus, on the screen you can see a slide from OSCE SMM Deputy Chief Alexander Hook's briefing for the Diplomatic Corps of 1st June 2018, depicting a school building in Teple, Lugansk region, occupied by Ukrainian forces. You can also see students outside the school building. The Amnesty International report, the organization which has always been far from sympathizing with Russia, pointed out in its report of 4th August 2022 that, I quote, Ukrainian forces have put civilians in harm's way by establishing bases and operating weapons systems in populated residential areas, including in schools and hospitals. In February 2022, while the Russian Federation, in order to protect the civilian population and avoid needless losses, provided humanitarian corridors for the evacuation of civilians and foreign nationals in the Kyiv, Chernihiv, Sumy, Kharkov, Mariupol areas, on at least 26 occasions, the Ukrainian side always categorically refused to allow citizens to safely evacuate to the Russian territory. Madam President, members of the Court, last Monday, Russia has shown you the Nazi roots of the Kyiv regime. Ukraine's agent had nothing to say to that except dismissing everything as lies. The reason is simple. Ukraine cannot argue against the plain historical truth. Here is another example. As Ukrainian President Poroshenko poses with his troops, a soldier boldly and prominently wears a large emblem of the 3rd SS Panzer Division Totenkopf, which was formed from the concentration camp guards and became notorious for brutality and war crimes, including mass killings of French and British prisoners. Poroshenko was the one under whose leadership Ukrainian troops devastated Donbass. Ukraine's agent had the audacity to quote this man as saying that it was Russia who attacked Donbass, not Ukraine. You have already seen the Donetsk Alley of Angels, memorials to children killed by Ukrainian strikes. Just these days, in Canadian Parliament, President Vladimir Zelensky, together with Canadian high-level officials, honored by a round of applause a person who served in notorious Nazi military unit during the World War II, SS Kalichina. Madam President, members of the court, in its presentation before this court, Ukraine attempts to conceal its fault for numerous hits on civilian objects and blames Russia instead. I shall begin with Ukraine agents blaming Russia for a missile attack on market in Konstantinovka on 6 September 2023. Evidence showed that the strike, which killed 17 civilians, including one child, was by Ukrainian anti-aircraft missile. Even Western media, such as New York Times, admitted that, but not Ukrainian agent. After this publication saw the light of day, Ukraine threatened the American journalists with criminal prosecution. Last Tuesday, Ukraine's agent, as well as one of Ukraine's counselors, once again mentioned the so-called Bucha massacre. However, that story is full of holes as any other coming from Kyiv. To begin with, Ukraine has still not provided any data on persons allegedly killed in Bucha. In September 2022, Russian Foreign Minister Sergei Lavrov has called on United Nations Secretary General Antonio Guterres to get the Ukrainian authorities to publish a list of people killed in Bucha. No reaction followed. No post-mortem examinations or even names of the deceased were provided. No relatives of the deceased have appeared in the public space. We do not know the basic results of the investigation. Ukraine is silent beyond the initial broad allegations. On 31st March 2022, when Mayor of Bucha, Anatoly Fedoruk, entered the town with Ukrainian forces, he recorded a congratulating video on the YouTube. In that video, there are no hints of any tragedy on the streets littered with corpses, only happy smiles and pleasant words. On 2nd April 2022, the National Police of Ukraine published video footage of Ukrainian forces entering Bucha. Again, no reference to any massacre is made. No dead bodies can be seen in this footage. Then suddenly, on 3rd April, a Ukrainian newspaper publishes an article about hundreds of murdered civilians allegedly discovered lying on the streets in Bucha. This information bomb then exploded all over Western media. Later, in September, an Italian journalist who was present at the scene in Bucha in the first days of April said in public statement that he saw Ukrainian military and civilians taking corpses out of trucks and laying them on the road in piles. Corpses which were tied with very clean bandages despite there having been heavy rains in Bucha for the 2 previous days. He also said that a volunteer informed him about corpses being taken from other locations to Bucha and then laid out for media to photograph. As with the other incidents, Kyiv was eager to shut down any questioning of the official narrative. In August 2022, the Kyiv City Prosecutor's Office brought charges of denial of the Russian armed aggression against a local resident of Irpin, Kyiv region. According to the case file, the accused woman denied the facts of murders and violence against civilians by the Russian military in her phone conversation with relatives. Irpin is located very close to Bucha. The 2 towns are separated only by the bridge blown up by the Ukrainian forces during their retreat, a photograph of which Mr. Gimli showed in this courtroom on 7th March. On Tuesday, Ukraine once more accused Russia of destroying the Kakhovka hydroelectric power plant, which resulted in flooding, the death of dozens of people, and an ecological disaster. However, facts again indicate that Ukraine is behind this crime. Perhaps the most brazen accusation of all was made by Ukraine's agent about Russia's alleged attack on Zaporozhye nuclear power plant. Russia has been in control of the plant since 1st March 2022, and it is Ukraine that has been shelling it and the neighboring town of Energodar for over a year. During discussions of these shelling incidents at the UN Security Council, not even Ukraine supporters accused Russia of attacking the plant its forces were controlling. The IAEA briefing Ukraine's agent cited had not named Russia as the attacker. Finally, Ukraine's agent voiced an incomprehensible allegation that by blockading Ukrainian ports, Russia has destroyed or held hostage millions of tons of grain, worsening global food shortages in Africa and beyond. Firstly, as you can see on the slide, it is the prosperous intervening states who were consuming the lion's share of the grain deal shippings, while African countries only received a tiny portion. Secondly, it is the sanctions imposed on Russia by the intervening states and their allies which block export of Russian grain, grain that could feed those in need in Africa and Asia. Thirdly, it is Ukraine's continuous attack on Russia's Black Sea objects, including civilian infrastructure such as the Crimean Bridge, which necessitated measures against Ukraine's maritime facilities. Madam President, distinguished members of the Court, I have described the various ways in which Ukraine misled this Court. However, it is not alone in this practice. I will now turn to what the intervening states do not want you to hear. I'm of course talking about NATO states and their supporters who in 1999 attacked Yugoslavia, inflicting death and devastation upon that country in the name of stopping so-called genocide of Kosovars. Declared NATO's humanitarian intervention turned out to be a humanitarian catastrophe. On 31st May 1999, even before the end of NATO's bombing, the High Commissioner for Human Rights reported more than 1,200 civilians dead and about 4,500 injured as a result of the NATO bombing. NATO destroyed bridges, schools, hospitals, places of worship, making people seek shelter and separating children from their parents. NATO used cluster and graffiti bombs in densely populated areas, putting civilian lives in enormous danger and leaving them without water and electricity. In another report, High Commissioner for Human Rights highlighted the following. In the NATO bombing of the Federal Republic of Yugoslavia, large number of civilians have incontestably been killed, civilian installations targeted on the basis that they are or could be of military application, and NATO remains the sole judge of what is or is not acceptable to bomb. NATO states had no reason to attack Yugoslavia in self-defense, nor have they invoked Article 51 to that effect. Their sales-style humanitarian intervention was performed under one pretext, stopping an alleged genocide in Kosovo. That, with all due respect, is not true. Last week, Mr. Ko went as far as saying, nobody stated there was a purpose to prevent genocide. That, with all due respect, is not true. Russia has already provided in its preliminary objections a long list of statements from high-ranking officials of NATO countries, claiming they were acting for that precise purpose. I will now remind the Court of these statements as well as provide some new ones, including the ones belonging to Mr. Ko himself. The US President Bill Clinton had declared, "This was genocide in the heart of Europe. We must apply that lesson in Kosovo." NATO stopped deliberate systemic efforts at ethnic cleansing and genocide. The UK Prime Minister Tony Blair had declared, "We fought this conflict because we believed it was wrong to have ethnic cleansing and racial genocide here in Europe towards the end of the 20th century. The German Chancellor Gerhard Schröder stated that genocide in Yugoslavia cannot be met with pacifism. The Prime Minister of Spain, José María Aznar, said, "NATO must be on watch for any crisis in the world. I support the attacks. Ethnic cleansing, genocide cannot be the rules we live by." The Minister of Foreign Affairs of Poland told the General Assembly, "We have to come to accept that absolute sovereignty and total non-interference are no longer tenable. There could be no sovereign right to ethnic cleansing and genocide." Almost every intervener in the present case supported NATO's bombing of Yugoslavia under the pretext of so-called humanitarian intervention aimed at preventing genocide and ethnic cleansing. The intervening NATO countries did not hesitate to openly reveal the purpose of the NATO's attack on Yugoslavia before this court back in 2004. In particular, Germany plainly declared that it is a matter of common knowledge that the military operations against Yugoslavia were undertaken in an attempt to rescue Kosovo Albans from being subjected to atrocity, including genocidal acts. Italy also openly admitted before this court that NATO's purpose was preventing genocide. And I quote, "The Atlantic Alliance was compelled to intervene to prevent an ongoing genocide." a group of states have felt compelled to intervene against a state to halt genocide. To make another example, Canada made the following statement: genocide is the gravest of international crimes. Canada's participation in the NATO air operation was prompted by a pattern of events in Kosovo that has shocked the conscience of the world. Even those interveners who were not NATO member states still supported the bombing campaign under the pretext of preventing genocide. Poland's Prime Minister Buzek, voicing support for NATO bombings, had stated, "There is no question that what is going on in Kosovo is genocide." I now come to the past statements of Ukraine's Council, Mr. Harald Kohl. On 24 April 1999, 1 month into NATO's bombing campaign against Yugoslavia, Mr. Kohl, in his capacity as US Assistant Secretary of State, speaking before the UN Commission on Human Rights in Geneva, stated the following: "It is impossible for me to introduce my country's resolution on human rights situation in the former Yugoslavia without referring to the catastrophic human rights violations taking place in Kosovo. We are witnessing a mass human rights epidemic that includes war crimes, crimes against humanity, grave breaches of international law, and indicators of genocide." It was not a single instance. Mr. Kohl repeated his allegations of genocide at various forums. On 16 April 1999, he had spoken at The Hague, saying that, "As we speak, the region-wide killing, raping, shelling, burning, deportations continue in Kosovo. In the Balkans in the 1990s, we have similarly witnessed the rise of ethnic cleansing, a massive human rights violation, and that includes war crimes, crimes against humanity, and acts of genocide." On 18 April 1999, he reiterated his claim in Skopje: "We are witnessing a mass human rights epidemic that includes war crimes, crimes against humanity, grave breaches, and acts of genocide." Neither were these statements purely humanitarian in nature. On the contrary, Mr. Kohl had used allegations of genocide to directly promote NATO's military intervention in Yugoslavia. And I quote, "Such a massive human rights crisis demands immediate and major human rights response. 50 years after Nuremberg, our only choice cannot be to sit back, watch ethnic cleansing occur, and only then seek accountability after the act. The United States, the Netherlands, and their NATO allies exhausted all diplomatic avenues before finally turning to force, backed by diplomacy, justified by international law and humanitarian necessity. We must continue this course until these victims can return to their homes in freedom." As you can see, contrary to what Ukraine says, NATO had acted under the pretext of preventing genocide. Moreover, Ukraine itself had slammed Belgrade actions in Kosovo and said that its refusal to implement relevant Security Council resolutions led to the use of force by NATO. And I quote, "Belgrade's refusal to sign these agreements formulated by the contact group had resulted in the breakdown of negotiations. Therefore, the provisions of the relevant Security Council resolutions had not been fully implemented and had led to the use of force." Ukraine also stated that a peaceful political settlement was possible on the basis of granting a wider autonomy to Kosovo. In an astounding volte-face, Ukraine then refused to implement the Security Council Resolution 2202, endorsing the Minsk agreements, which stipulated the granting of autonomy to Donbas, and instead chose to aggressively attack DPR and LPR, thus leading to the use of force by Russia. Madam President, members of the Court, now I will address contributions of intervening states in this process. The intervening states have shown that they possess no genuine interest in interpretation of the Genocide Convention, but are instead guided by purely political expediency and act in direct contradiction to their previous legal positions expressed before this Court. The common cause between Ukraine and the interveners is so obvious that restating it would be almost right. They make no secret of it, instead brandishing various joint declarations and open admissions of close cooperation. Despite their self-professed interest in interpreting the Genocide Convention, they have never chosen to intervene before in cases related to it, even when actual allegations of genocide were at stake. Russia has already drawn the Court's attention to the joint statement of 20 May and 13 July of 2022, signed virtually by each intervener. Ukraine's allies explicitly state that they, I quote, welcome Ukraine's application against Russia and joint intention to explore all options to support Ukraine in its effort before the ICJ. This common purpose was so apparent at the oral hearings, there is no need to give example, except perhaps of one of the most extreme. Latvia went as far as directly quoting the speech of Ukraine's consul, Monsieur Tuvenon, while restating support for his views no less than 3 times in a row. No better illustration of total lack of original interpretation or interest can be provided, except perhaps this collective photo of the interveners together with Ukraine's legal team. The representative of France openly underlined close coordination efforts provided by all the member states of the European Union in this regard. However, the interveners go well beyond common purpose. Their interventions also betray commonality of substance, often literal, with parts being identical to the letter. You can appreciate some glaring examples of such plagiarism on the slide. These suspicious similarities have not gone unnoticed in the international juridical community. A group of international lawyers have published recently a research report dissecting these interventions and have come to a rather obvious conclusion, and I quote, whether the stark similarities between the argumentation of many of the intervening states flows from a non-paper circulated among the states, or simply some states followed the lead of others, cannot currently be verified. However, our finding seems to suggest a somewhat sheep-like behavior pattern of many intervening states by uniformly adopting arguments from elsewhere. Another example of the interveners' hypocrisy is Germany, which addressed Russia's admissibility objection contained in a document in which Germany did not or should not have had access to. Further, the metadata shows that France, Portugal, the United Kingdom used the same author to prepare their observations. However, even when the court urged the states to group their submissions to preserve good administration of justice, most of these countries refused to make joint statements. The reason is clear. The interventions in this case are not used to genuinely interpret the convention. They represent an attempt to hypnotize the court by pronouncing Ukraine's position as many times as possible, or to put pressure on the court by presenting an appearance of overwhelming support of its position. Madam President, but the far more egregious example of intervening states' duplicity is the plain contradiction of their current claims with their own legal positions, as expressed in the legality of the use of force cases. As Russia has shown before, the NATO states had openly stated that they attacked Yugoslavia under the pretext of preventing genocide. This was done not only by their leaders on the political plane, but also by their representatives in this court. To list just a few examples, Italy contended before this court. It is accordingly clear that Atlantic Alliance was compelled to intervene to prevent an ongoing genocide. A group of states who, much against their will, have felt compelled to intervene against a state to halt genocide. Germany, in turn, stated before this court, it is a matter of common knowledge that the military operations against Yugoslavia were undertaken in an attempt to rescue the Kosovo Albanians from being subjected to genocidal acts. More than that, intervening states have previously held drastically different position on the interpretation of Article 9 of the Genocide Convention and its cooperatione materia. Now the NATO states have drastically shifted their position regarding aforementioned issues. On this topic, in 1999, Germany had stated in its preliminary objections, Article 9 of the Genocide Convention could provide the only basis for jurisdiction. However, given the absolute lack of information regarding the subjective ingredient of the crime of genocide, that clause is simply inapplicable. There can be no question of a dispute relating to the interpretation, application, or fulfillment of the Convention. Germany went on criticizing Yugoslavia case against it. Even a short glance at Yugoslavia's memorial reveals instantly that Article 9 is referred to in a last-ditch effort to find the basis for submitting the case to the court. The bulk of the dispute lies outside the confines of the Genocide Convention. As far as, in particular, the principle of non-use of force, the principle of non-intervention, and the duty not to harm the environment are concerned, the jurisdiction of the court has never been established either in the Charter or in treaties and conventions in force. Now, however, Germany espouses a diametrically opposite view. And I quote, Article 9 of the Genocide Convention also covers disputes in which one state party of the convention alleges that another state party is committing acts of genocide, and where, relying on such accusations, the former state party then takes action in the form of using military force against the latter. In another example, in 1999, France argued, the court is without jurisdiction to rule on the issues concerning alleged violations of United Nations Charter and certain principles and rules of international humanitarian law applicable in armed conflict, as those issues do not fall within the provisions of Article 9 of the 1984 Genocide Convention. But now France claims the exact opposite. Indeed, since Article 9 sets forth that the court may be seized of all disputes relating to the present convention, the fact that certain acts or omissions at the origin of the dispute may be subject to different legal qualifications, which may fall within the scope of instruments other than 1948 Convention, has no bearing on the application of this provision. France repeated this during the oral hearings. Disputes involving improper allegations of genocide or relating to improper use of the obligation to prevent and punish genocide therefore fall within the scope of the provisions of the Genocide Convention and consequently within the scope of the consent provided for in Article 9 thereof. Is that to be considered a genuine position by the intervening state? The Russian Federation does not believe so. Given that under this approach France or any other intervener may do another U-turn on its interpretation of the Genocide Convention once it would benefit them. It becomes even more evident when we observe France blaming Russia for its special military operation in Ukraine and at the same time supporting military intervention in Niger. To take yet another example in the legality of the use of force case, the United Kingdom asserted the following. Jurisdiction under Article 9 would not extend to disputes regarding alleged violation of other rules of international law, such as provisions of the United Nations Charter relating to the use of force and the Geneva Conventions and additional protocols of 1997 relating to the conduct of armed conflict. At the same time, in its written observations, the United Kingdom claims Article 9 of the Genocide Convention confers upon the court jurisdiction ratione materia to determine the extent to which Article 1 allows or requires a contracting party to engage in certain conduct that might otherwise be unlawful under international law. The United Kingdom was especially brazen in its oral assertion. The scope of other rules of international law that constrain conduct permitted by Article 1 is not indefinite. This is not the case for the constraints within Article 1. It is unthinkable that a state fulfilling its undertaking to prevent genocide in good faith could do so through aggression or other international crimes. And yet, it was the United Kingdom which, along with other NATO states, committed aggression against Yugoslavia under false pretext of genocide in Kosovo. It is clear. To align their position with the one of Ukraine, the interveners now have to claim the exact opposite of what they claimed some 25 years ago. But it is not the content of the Genocide Convention that changed over the past quarter of century. It is the political motivation of Ukraine's allies. However, with such change of position, they risk nothing. I would like to finish this part of my speech with another extremely pertinent quote from Germany's preliminary objections. Article 9 must not denigrate into a weapon for the purpose of frivolously discrediting an adversary. The jurisdictional requirement of Article 36 have precisely as one of the main objectives to protect a respondent from utterly baseless claims. Whether they are fulfilled must therefore be considered with the utmost care. This is necessary, in particular, with the view to shielding the authority of the Genocide Convention from being abused in instances where any other attempts to find foundation of the Court's jurisdiction has failed. I can only hope the Court follow this astute approach. Madam President, esteemed judges of the Court, the only conclusion, then, can be drawn from the interventions is that they are not genuine, contravene the interveners' prior positions taken before this Court, and amount to abuse of process. In this context, I would like to draw your attention to the document which has been adopted 2 days ago at the United Nations, the political declaration of the 4th Ministerial Meeting of the Group of Friends of the Defense of the Charter of the United Nations and undersigned by 18 states. This declaration includes the following appeal. We reaffirm the principle of peaceful settlement of disputes and express our firm conviction that states shall resolve their disputes through the dispute settlement mechanisms that they have agreed upon, and underlined that all means of settlement of disputes should be used in good faith and in the spirit of cooperation in order to resolve the goal of resolving disputes in a peaceful manner, in accordance with applicable international law, and thus leading to de-escalation of tensions and the promotions of friendly relations and cooperation among states. In accordance with the Charter of the United Nations, in this regard, we stress the importance of safeguarding the credibility and independence of the principal judicial body of the United Nations, as established by the Charter of the United Nations, and caution against the misuse of Article 63 of the ICJ Statute. This is what we are facing now, a blatant misuse of the right to intervene and of the Genocide Convention by the very states which have previously used genocide as a pretext in order to launch the attack on a sovereign state, all the while claiming that the Court has no jurisdiction to entertain claims under the Genocide Convention regulating their use of force. But now, when they need to support their client Ukraine, and the only way to do that is claim the opposite of their previous legal views, they do so without shred of hesitation. Such inconsistent statements and hypocritical attitudes of the intervening states should have no effect on the interpretation of the Genocide Convention. It is plain that these statements are made for purely political purposes and should not be given any legal value or force in the interpretation of the Genocide Convention. If anything, the actual legal position of the states before this Court in cases concerning themselves should be taken as the real reflection of their understanding of the Genocide Convention. The interpretation of a document so crucial as Genocide Convention should not be bent at will to serve political goals of one group of states. Madam President, members of the Court, I will not touch upon the countless flaws of Ukraine's legal position. Our Council will deal with them shortly. But I will emphasize key points. If Ukraine's views were to be accepted by the Court, it would be the first time when the Court would ascribe a legal basis for the use of force or recognition of states to a state that took these actions, and it would be done explicitly against its will. It would also overturn the entire international legal system with regard to critical rules bearing the nature of jus cogens, the right of self-defense and the right to self-determination of peoples. Following Ukraine's logic, any action in self-defense or recognition of states would fall under the Court's jurisdiction whenever their invocation is even remotely linked, including only on political plane, to subject matter of a treaty with a compromissory clause, be it anti-terrorism, racial discrimination, genocide, or any other topic. Any such remote link would, according to Ukraine, potentially engage the Court's jurisdiction regarding states' responsibility in respect of both the treaty and the jus cogens norm. Needless to say, that would be completely contrary to the fundamental principle of voluntary jurisdiction and will severely upset the realm of international law. Madam President, esteemed members of the Court, I will now introduce the advocates who will present these and other arguments in more detail. Will explain further Russia's first preliminary objection, namely that there is no dispute between Ukraine and Russia under the Genocide Convention. Professor Neumann will continue with the second objection on the lack of the court's jurisdiction on the matter. Professor Singho E. will go on with Russia's third objection on the inadmissibility of new claims and the fourth objection on the lack of authority. Mr. Kirill Udovichenko will further demonstrate Russia's fifth objection that Ukraine's claims seeking reverse compliance declaration are inadmissible and that Ukraine's claim constitute an abuse of process. He will also briefly comment on the matter of the order on provisional measures, which is not appropriate for the discussion at the present stage. Finally, Monsieur Jean-Charles Chikayar will give a presentation on the issue of Article 9 and will address some of the points made by the interveners. I thank you, Madam President, and honourable members of the Court for your attention. I now kindly ask you, Madam, to invite Professor Hadi Azari to address the Court, unless you would like to announce a coffee break.
I thank the agent of the Russian Federation, and I invite Professor Hadi Azari to take the floor. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you, Madam President. Madam President, distinguished members of the Court, in my oral presentation on last Monday, I had explained why no dispute existed between the parties under the 1948 Genocide Convention, which should therefore bring the Court to decline its jurisdiction to entertain Ukraine's claims. Ukraine's counsel contended on Tuesday that Russia was wrong both from a legal and factual standpoint, which this is not the case. As to the law, Russia's legal position relies on the Court's established jurisprudence, and Russia is not requesting the Court to change its approach, but in fact to confirm it and to apply it to this case. As to the facts, Ukraine's position does not meet the standards set by the Court. I will address these 2 points successively. On Monday, I emphasized that according to the Court's established jurisprudence, in order to conclude that a dispute exists, the Court must establish, based on evidence presented to it by both parties, that on the date on which the application was filed, the respondent, or rather the applicant, positively opposed the respondent positively opposed the applicant's claim. I have concluded that Ukraine's application must be dismissed because Ukraine has not proved that before filing its application it had claimed a breach of the 1948 Convention and that its claim was positively opposed by the Russian Federation. Ukraine's counsel did not engage in this discussion. Counsel did not demonstrate the opposite. She merely claimed that the approach was erroneous and that Russia is attempting to impose novel requirements that have already been dismissed by the Court. I shall demonstrate today that far from being novel requirements, Russia's approach is firmly entrenched in the Court's jurisdiction, and therefore there is no valid reason for departing from it in the present case. Distinguished members of the Court, the Court has detailed the test for the existence of a dispute in the Georgia versus Russian Federation case as follows. The Court now turns to the evidence submitted to it by the parties to determine whether it demonstrates, as Georgia contends, that at the time it filed its application and with respect to the interpretation of application of cert, it needs to determine whether Georgia made such a claim and whether the Russian Federation positively opposed it, with the result that there is a dispute between them in terms of Article 22 of cert. End of quote. The Court examined this evidence In the light of this test, including through letters, statements, and acts of parliament and other documents that Georgia had introduced, the court had dismissed everything that did not include a claim or a reproach or an accusation or an allegation made by Georgia against Russia. However, in order to establish the existence of a dispute, the court only used evidence that contained the claims made by Georgia against Russia, and only for this reason. The court concluded, and it appears on your screen, the court observes that while the Georgian claims of 9th to 12th August 2008 were primarily claims about the allegedly unlawful use of force, they also expressly referred to alleged ethnic cleansing by Russian forces. These claims were made against the Russian Federation directly and not against one or other of the parties to the earlier conflicts, and were rejected by the Russian Federation. The court concludes that there was a dispute between Georgia and the Russian Federations about the latter's compliance with its obligations under cert as invoked by Georgia in this case. End of quote. The Georgia versus Russia case has made case law, indeed. President Awada, Judges Seema Abraham, Donahue, and Judge Ad hoc Gaillard have observed in their joint opinion attached to this decision that it appears from the grounds retained by the court that a dispute only exists if, before filing the application, the applicant has notified the respondent of its claims and if the respondent has positively opposed these claims. The fact remains that the said jurisprudence has been followed to this day in other cases as well. For example, in Belgium versus Senegal, the court concluded that there was no dispute between the parties after having found that the documents relied on by Belgium did not clearly indicate what conduct it accused the respondent of. This is the conclusion of the court on the screen, and I will only read the relevant parts that are highlighted. Neither document stated or implied that Senegal had an obligation under international law to exercise its jurisdiction over those crimes if it did not extradite Mr. Habré. In the light of the diplomatic exchanges between the parties reviewed above, the court considers that such a dispute did not exist on that date. As I mentioned last week, it is this requirement that the applicant must meet to make its claim against the respondent that led the court to specify in the Marshall Islands case that the applicant must demonstrate, and I quote, that the respondent was aware or could not have been unaware that its views were positively opposed by the applicant. End of quote. In the same instance, by applying the test to the declaration relied on by the applicant, the court concluded that there was no dispute between the parties. Indeed, the court held that this statement invoked by Marshall Islands, and I quote, the statement is formulated in hortatory terms and cannot be understood as an allegation that the United Kingdom or any other nuclear power was in breach of any of its legal obligations. It does not mention the obligation to negotiate, nor does it say that the nuclear weapon states are failing to meet their obligations in this regard. End of quote. The court also dismissed the second statement relied on by the applicant because it said that it does not specify the conduct of the United Kingdom that gave rise to the alleged breach. The focus or the emphasis on the respondent's allegedly unlawful conduct. The lack of clarification and identification of this conduct is what led to the Marshall Islands application being rejected. the court has applied the same test to the claims made by Nicaragua in the case of the alleged violation of sovereign rights and maritime spaces in the Caribbean Sea. The court ruled that a dispute between the parties existed because, and as long as, and I quote, Colombia was aware that its enactment of Decree 1946 and its conduct in the maritime areas were positively opposed by Nicaragua. End of quote. The court cannot have been any clearer. These cases show that for the International High Court, a dispute exists if, and only if, the applicant is able to prove that it had accused its opponent of allegedly unlawful conduct, and if the opponent had positively opposed this claim. Furthermore, it needs to show that the respondent was aware that its views were positively opposed by the applicant. This is how a legal dispute crystallizes and becomes justiciable. Ukraine and the intervening states relied heavily on the Gambia versus Myanmar case. They would not have done so had they read it more attentively. In this case, the court did not depart from its jurisprudence that I just described. Two statements by Gambia were in question. The statement from September 2018 and the statement from September 2019. Both involved reports made by the fact-finding mission of the UN Security Council. The 2018 statement or report, I'm using the court's wordings, contained specific allegations on the perpetration of crimes in the Rakhine State whose nature, seriousness and magnitude was similar to the crimes that had enabled the establishment of genocidal intent in other contexts. However, the 2019 statement expressly referred to Myanmar's responsibility under the Genocide Convention. And the court held that, and I quote, Myanmar's rejection of the findings of these reports demonstrates that it was positively opposed to any allegations of genocide being committed by its security forces against the Rohingya communities in Myanmar, as well as to the allegations of its responsibility under the Genocide Convention for carrying out acts of genocide. Such allegations were contained in the two reports and publicly taken up by the Gambia. End of quote. Therefore, Myanmar, the respondent, was clearly aware that its conduct, that is to say the treatment of the Rohingya group, was what the applicant was holding against it, and that it was accused of having violated the Genocide Convention and could thus be brought before the court. Even if the convention has not expressly been mentioned in the statements made to the UN General Assembly, the parties debated the question of the state's responsibilities for committing genocide. They did so in the light of the conclusions of the reports of the fact-finding mission containing specific references to the Genocide Convention. Whether Ukraine and the intervening states like it or not, in Gambia versus Myanmar, there was indeed an allegation made against the respondent, which was positively opposed by the respondent. Two elements sine qua non, therefore, of the existence of a dispute, both of which are absent in the present case. Distinguished members of the court, you had made it clear the court does not accept surprise introductions in this case. The applicant must formulate legal claims against the respondent before filing its application so that the respondent is made aware of what its alleged unlawful behavior is and to act accordingly. Ukraine and the intervening states repeated constantly that the concept of a dispute is vast, and this doesn't help Ukraine, quite the opposite. The court, in this manner, so many rules for a dispute to exist, and it would not have dismissed so many applications and requests submitted to it in the past due to the breach by applicants of such requirements. The claim that the existence of a dispute is a question of merits and not form or procedure, often mentioned by Ukraine and certain intervening states, does not indicate that the applicant is free to comply with these requirements or not. It only means that it is free to choose the means to make its claim against the opponent and to manifest its opposition to the respondent's conduct. Madam President, I now come to the second part of my presentation relating to the facts of this case. If you wish, Madam President, we can break at this point, or I can continue, if you so desire.
For raising the question, let's continue for another 15 or 20 minutes. When you get to a suitable point in 15 or 20 minutes, please let me know and we can take a break then. Thank you.
Ukraine intends to base the court's jurisdiction on Article 9 of the 1948 Convention. Therefore, to establish its dispute, Ukraine must demonstrate, 1, that it has claimed that Russia has breached the 1948 Convention through allegedly unlawful conduct, 2, that its claim was positively opposed by the Russian Federation, and 3, that the disagreement between the parties existed on the date on which the application was filed. As I explained last week, Ukraine has failed to meet these conditions. Its council did not contend the contrary last Tuesday either. The assertion by one party that a dispute exists is not the factor that determines if indeed the dispute exists or not. It is for the court to decide this by taking into account, in particular, any statements or documents exchanged between the parties. The fact is that in this case, there is no trace of any statements or documents exchanged between the parties that relate to the alleged dispute presented to the court. Even though Ukraine has communicated extensively with the Russian Federation on measures on numerous issues between 2014 and 2022, it has never made any reference to the Genocide Convention or its object, either in diplomatic correspondence or in any other way that would have enabled the Russian Federation to be made aware of its position. Being aware of the weakness of Ukraine's position, some intervening states attempted to defend Ukraine's inaction. The United Kingdom contended that the court had expressly recognized that a dispute can exist even in the absence of diplomatic exchanges. End of quote. However, this observation applies to situations where there is no communication between the parties. Naturally, the absence of such communication should not prevent the court from being seized. However, this logic cannot apply to a situation where the parties have been in communication actively since many years, but no reference has ever been made to the alleged subject matter of the dispute by the applicants in its communications.
Madam President, might I repeat that between 2014 and 2022, Ukraine and the Russian Federation exchanged an extensive diplomatic correspondence, both long and continuous. Their representatives met on numerous occasions in various settings, both bilaterally and multilaterally. Yet, Ukraine did not once refer to the Genocide Convention or its object. Ukraine sent hundreds of diplomatic documents to the Russian Federation on a number of issues, but not one relating to the Genocide Convention or its object. Distinguished members of the Court, as I pointed out last week, Ukraine has been at pains to convince you that the dispute did nevertheless exist on the date of the filing of the application, since Russia had accused Ukraine of having committed genocide, and that Ukraine had challenged Russia's claim. This is a matter pertaining to Russia, not Ukraine. However, Ukraine's attempt to reverse the test for the existence of the dispute is bound to fail. The court itself will, of course, ensure consistency with its jurisprudence. However, I shall demonstrate that even if one were to apply this reverse test, Ukraine's line of argument is entirely unfounded. Regarding the declarations made by Russian politicians, which contained the term genocide, one can but admit that a simple use of this term does not suffice to establish the existence of a dispute under the Genocide Convention. Last Monday, I quoted an article by William Shabas to support my claim that a distinction must be made between the use of the term genocide for rhetorical purposes or political purposes and an invocation of the 1948 Convention. It might be worth mentioning that at the very moment that Ukraine was denouncing this assertion in this room, President Zelensky was accusing Russia of committing genocide in his statement to the UN General Assembly. Other examples, and you will see some on the screen, show how frequently politicians utter this word. Cuban and Mexican leaders characterized the American embargo on Cuba as genocide. In 2023, Kenya's president characterized the situation in Sudan as genocide. Hugo Chavez, the president of Venezuela, utilized or used the word genocide in various statements he addressed to President Bush and to Israel. Examples abound. Needless to go through them all here. Council for Ukraine spent much time discussing Russia's investigative committee. The investigative committee is an independent body tasked, as is clear from its title, tasked with carrying out individual criminal investigations. And even assuming these investigations were to lead to a genocide allegation, the file would then be sent to a competent tribunal, the only one in a position to determine the soundness of a potential genocide allegation. The jurisdictional immunities case, referred to by several speakers, has no bearing whatever on the instant case. This case dealt with final judicial decisions, which clearly may and must be understood as an act of the state, unlike the committee's statements made during an investigation launched under the Russian Criminal Code. Here, yet again, they do not pertain to state responsibility for genocide, but to individual criminal responsibility. An investigation into the conduct of a person, which can lead to the case being closed for lack of evidence or because the court has been seized of the case, can under no circumstances point to the existence of a dispute between states. Ukraine's attempt to depict the investigation committee as a body representing Russia internationally must equally fail. First and foremost, because the law is unambiguous, the investigative committee clearly does not have such powers and duties. A body which does not represent the views of a state internationally cannot give rise to a dispute between states. Ukraine has indicated that the investigative committee has represented Russia at the international level, attending, for example, formal bilateral negotiations between Ukraine and Russia. However, in its slides, Ukraine has hidden the fact that the delegation was led by the Foreign Affairs Ministry, which is the body in charge of representing Russia at an international level, and that members of the committee had attended as experts on matters relating to mutual legal assistance, as you can see here on the screen. Besides, the two delegations met to discuss the ICSFT, which is clearly a criminal law convention covering individual criminal responsibility for acts of terrorism financing. In its judgment, the court, in its ruling on preliminary rejections in the ICSFT and CRD case, The court, as I said, has clearly stated that this convention did not cover what is called state terrorism or the financing of state terrorism. According to Ukraine's contentions regarding a purported prosecution by the investigative committee on Ukraine's international responsibility for genocide is entirely meaningless. As to Russia's reference to the ILC's articles on state responsibility, Ukraine and various intervening states have argued that Article 43 of the ILC draft articles on state responsibility, according to the draft's commentary, does not cover matters relating to jurisdiction or to the admissibility of a case. Ukraine and the states have misconstrued Russia's position. Russia did not raise this argument as an objection to the court's jurisdiction or to the admissibility of Ukraine's application, but rather as the proof of the absence of a dispute between the parties. In other words, it was invoked with a view to explaining that even if the word genocide was uttered by various Russian authorities, it was not an accusation made with reference to the convention. The answer explains, and it is right, that, and I quote, there is in general no requirement that a state which wishes to protest against a breach of international law by another state or remind it of its international responsibilities in respect of a treaty or other obligation by which they are both bound should establish any specific title or interest to do so. End of quotation. Ukraine's council has described the committee's work as 8 years spent on preparing a false justification for Russia's special military operation. Yet she did not explain why Ukraine had waited 8 years to seize the court if it truly believed that the committee's work ran counter to Russia's legal obligations under the convention. Distinguished members of the court, Ukraine contends that it was possibly opposed to Russia's genocide allegations and to the measures taken by Russia to prevent and punish genocide allegation in Ukrainian territory. The fact is that all the statements quoted by Ukraine's council to support this claim were made by authorities being looked into by the investigative committee. And these authorities themselves were addressing these statements to the committee itself. Thus, they were not responding to a state allegation, and their attitude cannot contribute to the occurrence of a legal dispute. Turning to the speech made on 23rd February 2022 by Mr. Kuleba, the Ukrainian Minister of Foreign Affairs, he clearly did not refer to a genocide allegation or to the Genocide Convention. Council for Ukraine does not contradict this fact. She said, and I quote, although Mr. Kuleba chose not to amplify the accusations of genocide made by Russia, he clearly and forcefully defended the actions of his government in Donbass and condemned the illegal recognition by Russia of the DPR and the LPR. Last Monday, I explained why Ukraine's reference to the Foreign Affairs Minister declaration on 26 February 2022 is of no use whatever to it. I demonstrated that the court has taken account of the reasonable amount of time which passed between the existence of the dispute and the filing of the application. Now, Mrs. Cheek responded that in view of the speed of the Russian invasion, the moment and the way in which the declaration was published does take nothing away from its relevance to confirm the existence of dispute referring to the Genocide Convention at the date of Ukraine's application. This argument, however, shows yet again that Ukraine has misused the 1948 Convention. Ukraine's underlying objective in filing the application is to obtain from the court a decision on Russia's military operation. In fact, the reason why Ukraine seized the court was not the genocide allegation, but the issue of the use of force. Reacting to the genocide allegation as an alleged violation of the 1948 Convention cannot be done through military means. Positive and clear opposition to the verbal allegation genocide was required. There has been no such opposition. The Council of Ukraine stated that the Ukrainian minister published a statement before filing the application and added, and I quote, "It is reasonable to presume that under circumstances of war, the Russian Federation would have monitored very closely any official declaration made by the Ukrainian Ministry of Foreign Affairs. This argument is untenable." The declaration was published just 4 hours before the filing of the application. This is simply not enough. The court's position as to the moment of the crystallization of the dispute is totally unambiguous. It has clearly stated that the rule according to which dispute must be exist at the time or prior to the filing of the application clearly shows it should be done before the application. Therefore, the defendant would have the possibility to react to the claim made by the applicant. I've just got a couple of pages left, Madam President, if I may continue, or should I stop now for a break?
Mr. Azari, you indeed are quite close to the end of your remarks, so please go ahead and complete them, and then we'll take the break.
Okay. Thank you. Merci beaucoup, Madame.
Thank you, Madam President. The Russian Federation was not in a position to react to the applicant's claim as expressed in the said declaration, all the more so since it was not supposed to have been informed. It must be recalled that in the Marshall Islands case, the court did not uphold the declaration made by the Marshall Islands during the Nayarit conference as evidence of an existence of a dispute with the parties, despite the fact that it contained a precise allegation on the alleged breach by the defendant of its international obligations. Why? Well, because, stated the court, the United Kingdom was not present at the Nayarit conference. One cannot assume that the defendant knew that its views were positively opposed by the applicant. Mrs. Cheek's contention, according to which Ukraine's self-defense actions against Russian aggression demonstrate in a way that Ukraine, by its action, opposed the purported genocide allegation, is unconvincing. With regard to a similar contention made by the applicant in the Georgia versus Russia case, the court stated that there was no link between the so-called exercise of self-defense and opposition to the alleged breach of the treaty invoked in dispute. The court's statement can be seen on the screen, and I quote, "The Russian Federation stated that through its military aggression, observed that this, I beg pardon, and that its military aggression required the exercise of right of self-defense as provided in Article 51 of the Charter and other documents. The court observes that this decree does not allege that the Russian Federation was in breach of its obligations relating to the elimination of racial discrimination. Its concern is with the allegedly unlawful use of armed force." End of quotation. Distinguished members of the court, this brings me to the last part of my presentation, the purported dispute relating to the abusive use of the convention condemned by Ukraine in its memorial. Last Monday, I explained why none of the prerequisites for the existence of a dispute were met by this claim. Last week, Ukraine said not a word about my contentions. This being said, I shall end by repeating the main aspects of my submissions regarding this purported dispute. 1. Ukraine's claims relating to the abusive use of the Convention are all based on false premises, according to which the Russian Federation had invoked Ukraine's responsibility for the Donbass genocide, and that it subsequently reacted unilaterally to put an end to it. This is wrong. There is no disagreement between the parties on this issue. When the parties, on one hand, and the court, on the other hand, agree that there is no right under the Convention, it would be absurd to complain then that there exists or may exist a dispute in its regard. 3. The Russian Federation became aware of Ukraine's claim at the time of the filing of its memorial. Yet, at the critical date of the filing of the application, this contention did not exist. Under those circumstances, one cannot conclude to the existence of a legal dispute between the parties on this count. For all these reasons, distinguished members of the Court, the Russian Federation requests that the Court decline to exercise its jurisdiction to entertain Ukraine's application in light of the absence of a dispute between the parties. Distinguished members of the Court, this brings me to the end of my presentation. I would like to thank you most warmly for your kind attention and would request that you, Madam President, call upon Mr. Alfredo Cruzata after the coffee break, if you so decide.
I thank Professor Azari. Before I invite the next speaker to take the floor, the Court will observe a coffee break of 10 minutes. The sitting is adjourned.